has announced that he will take the opinion of the Attorney General as far as this decision to sack the Cabinet Minister is concerned. What do you think the advice of the Attorney General will be? Does the Governor have the power to sack a minister?
No, absolutely not. It's a constitutionally imprudent act unbecoming of the Governor. Our Constitution doesn't in any way permit parallel administration, and as far as the role of the Governor is concerned, his involvement in the affairs has been nominal, the real executive being the Council of Ministers. The Constitution is absolutely emphatic. When you look at the Constitution, insofar as the Governor is concerned, he has to act. The Constitution, in fact, the Article 154 itself stipulates that he has to act in accordance with the Constitution. When you talk about in accordance with the Constitution and we talk about the entitlement for minister to continue, there are certain qualifications and disqualifications in the Constitution itself, which are manifest in 173 and 191 of the Constitution. So the particular person doesn't, in fact, suffer the disqualification, nor is he in any case in a position where anyone can legitimately allege, notwithstanding the criminal case, that he lacks qualifications. Insofar as the reason which he has given, that prerogative, as unlimited prerogative, is unknown to the Constitution. It is subject to law, has to be exercised in accordance with the terms, and the entitlement that the Governor has claimed for himself is something which is completely unknown to the Constitution.
All right.
For him to take the opinion of the Attorney General after having dismissed it itself shows that how completely out of form this entire conduct is. And a step as unprecedented as this, a step as extreme as this, a step as impermissible in the settled constitutional scheme, colliding as it does with the absolutely established constitutional precepts, ought to have been preceded by adequate deliberation. And had it been so preceded, we would not have faced this so unseemly and improper situation which we are seeing today.
All right. I think you've made it quite clear as far as the powers of the Governor are concerned. But let me also ask you this follow-up. The Governor maintains that he has already advised the Chief Minister to sack this said minister, and there were certain reasons for it, the minister's history and conduct. He feared that there cannot be a proper investigation as long as he continues to be a minister. Would you say that it is also incumbent on the Chief Minister to at least consider the Governor's request in such matters, or provide answers as to why he's not sacking the said minister?
You see, as far as the interaction with the Governor and Chief Minister is concerned, that moves in the realm of constitutional propriety and brings in question of constitutional morality. Ideally speaking, a person with criminal antecedents should not be in the Council of Ministers. The point is, unfortunately, the way in which our constitutional scheme is devised, merely because there is an accusation of criminal conduct against a particular person, doesn't in any way disqualify him. For disqualification, it has to be one under the Representation of People Act, or which entails conviction, or other grounds which are stipulated in the Constitution itself. No matter how reprehensible it might seem that a person against whom such accusations have been made continues to be in the Council of Ministers, there is no bar in the Constitution from his so continuing, the matter being one in the realm of the conscience of the Chief Minister in this particular case, and his alignment with the sense of propriety. But the legality of it is completely not open to doubt. And as far as the Governor is concerned, the Governor is so keen to uphold the law, the Governor should also be aware of the limits on his own power. And while purporting to enforce the law, he should not violate the law himself, because he is sworn to act in terms of it. The Constitution contains limits. It sets out the constraints and specifies the area within which the constitutional functionaries must act. And the actions of the Governor are in clear transgression of those limits.
All right. So there is the political aspect. There's, of course, the legal aspect. Aman Lekhi, I do thank you for joining us. And, of course, he's made the legal argument very, very clear. And possibly that is why the Tamil Nadu Governor, Mr. Ravi, has had to rescind his order, has had to re-look at it. Let me take this debate forward with our other guests. On that note, let me go across to our BJP representative. You know, this only strengthens the DMK's argument that the Governor is motivated against the current government. There was no need for the Governor to act in this manner when he clearly did not have those powers.
Ma'am, let me make this very clear on the show that the BJP is not the spokesperson of the Raj Bhavan. Unfortunately, it is a very shameful to note that even after so many allegations have been mounted against a said minister, after coming to light that he has swindled crores of money with the promise of offering jobs in the government transport department, especially where he was minister, the chief minister has failed to act. Now, there is not one person.
The reason I understand, I'll get to that in just a bit. I'll get to the case in just a bit, Vinodji. But, you know, the reason I ask you this question is because you've come out supporting the governor's actions.
We have not nowhere where we come out supporting the governor's actions. We are saying that Senthil Balaji should be dismissed. We are not getting into the dispute or the legal angle of whether what he has done is right or wrong. But we are of the stand that Senthil Balaji should be dismissed and he should face law as a common man after having such serious allegations leveled against him. Especially after the Supreme Court itself has come down heavily and said cases should be, the trial should be conducted against the conduct of Senthil Balaji. It is the duty of the Chief Minister to make sure that he has been asked to leave the ministry. But what have you done? 37 ministers go and sit in the government hospital at 2 a.m. in the midnight to save one man who the Chief Minister himself called corrupt. No one else. He was in fact the first person in 2016 who came out so heavily on Senthil Balaji, calling him corrupt. But it is very unfortunate that none of these ministers ever came out of their residence at 1 a.m. in the night for the sake of the 7 crore people of Tamil Nadu. But for one man, Senthil Balaji, the entire cabinet of ministers sat the entire night to save him.
This is not
so who are you trying to save? Or what are you trying to save?
This is not to go into the merit of the charges against Senthil Balaji. And I discussed that on the day that his arrest was made. This is indeed a very curious case, politically and legally. Politically, the DMK has in the past attacked this very same minister when he was in the AIA DMK, Mr. Stalin himself. And then legally, there are many points in this case where he received extraordinary relief by the High Court. But the Supreme Court had to step in at various points to ensure that the man is held accountable for his alleged crimes. But let me also stick to the issue of the governor today. I'll go to the DMK representative in just a bit. C.B. Pandey is former legal advisor to the governor of Uttar Pradesh. Mr. Pandey, do you believe the governor was misinformed or misadvised in this case that he could sack a minister despite the chief minister not agreeing to it?
This is a peculiar case. And so far as the general law is concerned, as per Article 164(1), the governor has no discretionary power. Though he has to act on the aid and advise of the Council of Ministers. This is general principle. And there is no dispute with regard to this law settled by the Supreme Court, as you mentioned, in different, some say in case and later Deputy Speaker case and all that. So though there is no discretionary power of the governor to act in such matter in the point, but at the same time, chief in the number of cases, it is not a bar. There is no bar to exercise the discretionary power as far as, for example, appointment of chief minister. The appointment of chief minister, in the case of appointment of chief minister, governor exercises a discretionary power.
True.
It not act on the council of ministers. That is one exception. Like that, there are other exceptions also. Here in this particular case, if I am talking about this particular case, so far general law is concerned, a governor has no power to dismiss a minister or to dismiss a chief minister. He has no power. But this area, in this particular situation, this issue has never been discussed before a Supreme Court or High Court, that in such situation where a man who is a criminal, who has been involved in so many criminal cases, or who has been committing some crime, suppose he had committed some murder. It's a corruption case, but suppose he has committed murder, and governor advised the chief minister to dismiss him, and he is not, the chief minister doesn't care about the governor's advice. So in that situation, whether the constitution is will be interpreted in a manner that no, he will continue even as a murderer in the cabinet, in the council of ministers.
No, but that's the,
So
I mean, whether we like it or not. Mr. Pandey, I asked exactly that question to Aman Lekhi earlier, and